we'll go ahead and get it kicked off. Hello, everyone, and welcome. I'm very excited to have you all join us for our first webinar of the new year. Today, we are covering Incoterms with a true subject matter expert in this field, Mr. Graham Catlett. My name is Jonathan Bricker, and I'm the chair of the Arkansas District Export Council. In my primary role, I work for Regions Bank, and I'm located in Northwest Arkansas, and I'm a commercial relationship manager. I want to begin today by thanking our sponsors, Arkansas Manufacturing Solutions and Arkansas Workforce Connections. Their sponsorship and partnership with us throughout the entire year are what makes these webinars so successful and free of charge to join. I really appreciate you all joining us today. For those of you that are here for the first time and aren't quite sure who the deck is and what we do, allow me to do just a quick introduction. We're a private, nonprofit organization that brings together experienced international business people with potential exporters. We have a ton of experience within our council and in many different sectors. Now, having said that, we don't know all the answers, but we can introduce you to someone who does. We're basically a community of connections within the exporting world, and we want to be your strategic partner and help you grow your bottom line. My hope for today is that you walk away from this webinar with more confidence in your exporting abilities. If you have any questions throughout the webinar and you don't feel comfortable asking them here, I invite you to reach out to us on our website, exportarkansas.org, and we'll have one of our members reach out to you. There, you can also sign up for our monthly newsletter, which is chock full of pertinent international news and trade show opportunities. Before we begin, I'd like to ask everyone to keep themselves muted and raise your hand if you'd like to ask a question, or simply put it in the chat. That way we don't have any background noise interrupting our speakers. So thank you all for your help with that. I'm going to introduce you to your moderator today, Mr. Rudy Ortiz. Rudy is the owner of Strategic Business Services, LLC, where he helps companies with a wide variety of international business and exporting needs. Rudy works alongside companies entering new markets, and he is a U.S. partner of Global Market Entry Consultants. With an MBA in international business, he is a certified global business professional, and for these reasons, he's the DEX Education Chair. Rudy, over to you.
Jonathan, thank you so much. I appreciate the intro. And folks, we're going to have a fantastic webinar today. The information that you're going to get is going to be incredibly useful. And in terms of Incoterms and those kinds of things, it's really difficult to see when companies do not pay attention to that and wind up paying dearly for it, losing not only their profits but their cargo and whatnot. So it's very, very important to understand Incoterms and to choose the right ones, to not only to be competitive but also to make sure that you limit your liability to the extent that you can bear. And as it turns out, the gentleman that we have today, Graham Catlett, is a subject matter expert in this field. And not only is he an international attorney, there are other international attorneys. What makes Graham really important and somebody who's going to really be able to provide some high level, high accuracy information is the fact is that not only is he an international attorney, but he also is an exporter and has been an exporter for many, many years. So he's not just a guy who knows the books. He knows what it really is like to be exporting. As a matter of fact, I think was the first individual to start exporting food products to what used to be the Soviet Union, and was quite successful at doing that. And he has other exporting endeavors over the last 30 years where he is dealing with companies in Europe and Asia and several other companies. And of course, he's also the managing partner for his law firm. And for those reasons, that's why we have Mr. Graham teaching this class today, because he knows the subject matter upwards, downwards, and sideways. And with that, Graham, take it away.
Thanks, Rudy, and it's a pleasure to be here with everybody. let me say that before I begin, there are two preliminary things I'd like to say. And the first is that I admire all of you for engaging in international trade in this particular time, because this is probably the most difficult time in my life for companies to engage in exporting or importing. And I encourage you to continue doing so, but I also admire you for doing so. The second thing is that we're going to talk about Incoterms today, and many of us are familiar with the basic abbreviated term, but we don't necessarily know that by using that term, it incorporates a lot of rights and responsibilities into our contract. So that you know what all those rights and responsibilities are, I urge you to get this book from the International Chamber of Commerce, because it details what those rights and responsibilities are. Today, we'll talk about what some of those are and how you can determine what rights and responsibilities you have, but I urge you strongly to get the book. The first thing for us to cover is a list of the topics that we want to talk about today. And this is the 8 topics that I want us to cover. And let me mention that at the conclusion of this presentation, you will be entitled to receive a copy of these slides. So don't necessarily think that you have to take good notes, but you will be entitled to the slides, as well as I mentioned, please get that Incoterms book, because it will go into even more detail. But the topics that I want to talk about today are, first, what the Incoterms rules do and what they do not do. And it's as important to know what they do not do as it is those things that they do apply to. Second is what happens if the Incoterm is not properly incorporated into your agreement. What does it mean for you and your rights and responsibilities? The third is we'll talk a lot about place, and what does place mean, and what are the legal significances of the term place, and which place are we really talking about? Fourth, what obligations are you incurring when you use an Incoterm? We'll talk about it a little bit more, but basically keep in mind that when you use one of these Incoterms, you are in effect incorporating pages of obligations on you, as well as some rights that you will receive into your contract that you may not realize when you just use the abbreviated term. Fifth, we'll discuss which Incoterms should be used in different cases. Sixth, what type of insurance is required when Incoterms requires insurance. We'll then go into a deeper dive into ocean-going shipments. And I want to bring up a legal case that covers some of these issues that we will have talked about. One of the most common problems with Incoterms is knowing what they do and what they do not do. And let me say that what they do is basically 3 things. First, the Incoterms set out the obligations between a buyer and a seller. As I mentioned before, by using the term, you will incorporate automatically into your contract certain obligations of the buyer and the seller. The second major thing that the rules do is determine when risk shifts from the buyer to the seller, from the seller to the buyer, sorry. And basically that is answered by when is delivery? When does delivery occur? And the third major type of thing that the rules do is having to do with costs and which party bears which costs. Now, what do the rules do not do? Well, the first thing is they don't create a contract of sale. And this is a common misunderstanding. The rules themselves are not a contract. And standing alone, they have no contractual authority, but they are to be included into your contract. So again, standing alone, the rules do not create a contract of sale, but they can be included into your contract of sale. The next thing the rules do not do is they do not establish the time, place, method, or currency of payment. All of those need to be specified separately in your contract. Next, the rules do not establish remedies for breach of contract. Fourth, they are not a force majeure. And finally, they do not discuss or resolve how disputes are to be handled, either as to the method, the law, or the venue. So those things are sometimes considered aspects of the rules, but they are not. The next common problem is what happens if the term is misstated? Does it require a very precise technical solution, or if you make a slight mistake, is it a problem for your contract? Well, the best way to incorporate a term into your contract is like this. First, specify the rule or the term. Next, name the port, place, or point. And then say Incoterms 2020. It's important to say 2020 because Incoterms are revised every 10 years. And there's a slightly different set of Incoterms that are 2010. And we'd expect there could be some slightly different ones in 2030. So it is important to put Incoterms 2020 as part of your incorporation of Incoterms into your contract. So for example, CIF, Shanghai, Incoterms 2020 is a proper way to state and incorporate the term into your contract. Or DAP number 123 ABC Street, Conway, Arkansas, Incoterms 2020. Both of those do follow the rule about how best to incorporate it. You see they have the chosen Incoterm, the named port, place, or point, and they end with Incoterms 2020. Now, sometimes you will see a description that looks like this: FOB Fayetteville, Arkansas, or FOB New Orleans, Incoterms 2020. Well, what do those mean? Well, you see the FOB Fayetteville, Arkansas may not include the Incoterms designation. And FOB New Orleans may not be a proper designation either. We'll talk about the effect of those types of things a little bit later, but I wanted you to see that there are differences in the way you see them sometimes, and they may not always be proper. You noticed that we use the trademark symbol, the R with the circle around it, and the year. I've already mentioned that it is necessary to use the year of the Incoterms because those change every 10 years. But it is not necessary to use the trademark symbol in incorporating the term into your sales contract. Now, the most common problems continue with the definition of what is the place because we saw that when you're specifying and incorporating an Incoterm into your contract, place is one of the things that you have to include. Well, which place? What place? The rule is that in all rules except the C rules, place indicates where the goods are delivered. And remember, we said delivery was important because it showed and designated the risk of loss shifting point. In D rules, the place is both the delivery and the destination. Going back to the first, in all rules except C rules, it only speaks to the place where the goods are delivered. But in D rules, it's delivery and destination. But in C rules, the place is the destination, but not the delivery. Now that can be a little confusing because when you're writing an Incoterm using a C rule, you will specify a place that is the destination, but it is not the point at which risk shifts. You'll see a diagram that shows that in a minute. Now, what does delivery mean? Delivery is an important place. It is the place where the risk shifts from the seller to the buyer. Now, the two extremes that we're probably familiar with is the closest to the seller is EXW or Ex Works. That means that the goods, the risk of loss for the goods shifts at the seller's place of business. The closest to the buyer is the DDP. So from a seller's standpoint, the seller would like to use Ex Works, where the buyer would like to use DDP. In other words, shifting that risk of loss at a point which is to the seller or the buyer's favor. Now, although those are the ideal, it's not always practical to use those two. And so we have to use some combination of the two for our point of risk changing. Now, when you get to the term place, you know, that may not be exactly precise because you say the place being the port of Houston or the point of or the port of Los Angeles. Well, those are big places. And so if you can, identify a point, if possible, to be more precise. Now, if there are multiple carriers involved, then there can be a difference between when the risk of loss shifts where there are multiple carriers. And you'll see a diagram that points that out in a minute. But just be aware that when you use a multiple carrier, make sure that you are describing the delivery point for risk of loss. The next most common problem has to do with the obligations you're incurring. You know, if we put in our contract Ex Works, then the seller may think, well, I don't have any obligations at all. Well, that's not exactly true, because for each of the Ex Works, there is a list of obligations of the seller and a list of the obligations of the buyer. So even though you may provide for Ex Works, or if you're the buyer and provide for DDP, there are still some obligations that you may have for using that Incoterms, and that's why you need to be familiar with all these different aspects of the obligations for which you are responsible. Now, we know there are several Incoterms, and so which one is the appropriate to use? Well, for any mode of transportation, you can use these: ex works, free carrier, carriage paid to, carriage and insurance paid to, delivered at place, delivered at a place unloaded, and delivered duty paid. So regardless of whether you're using ocean-going freight or truck freight or rail freight, all of these can be used in your contract. There are also 4 Incoterms that should only be used for sea and inland waterway transport: free alongside ship, free on board, cost in freight, and cost insurance and freight. Let me show you a neat little graphic which helps explain the principal, not all, but the principal points regarding a few of these Incoterms. And all this is going to be in the book that I recommended to you. The first one, let's start with free carrier, or FCA. The graphic, as you'll see, the blue represents the seller and the yellow represents the buyer. You see that there is a line for costs and a line for risks. And you see that for each of them, the costs are assigned to the seller up to a point, and then from that point forward, the risks and the costs are assigned to the buyer. So in this case, FCA, you see a truck, a yellow truck, the buyer's truck, with the goods on board. So you see the seller has the cost of putting those goods on board the truck, loading them on the truck. But then at that point, the costs of transportation shift to the buyer and remain with the buyer until the goods reach the buyer's place of business. Similarly, the risks. The risks of the seller continue until the goods are in the truck, but at that point, the risk of loss shifts to the buyer and remains with the buyer until the goods reach the buyer's place of business. Now you see the next graphic shows a little more confusing example, and that's where the seller is obligated to deliver to a point that is not the final destination of the goods. So the seller has the cost of loading the truck and paying the transport up to this place of delivery, and the seller has the risk of loss for the goods up until this place of delivery, even though the goods have not reached the buyer's destination. But from this point, the costs and risks shift to the buyer until they reach the destination. So under our terminology, the point of delivery is this point, this intermediate point that you see in the middle of the graphic. And we take a little bit more complicated example, which is carriage and insurance paid to, or CIP. You see that the cost is on the seller all the way until it reaches the buyer's place, but does not include unloading the truck. So the seller is responsible for the costs of loading the truck and for transport up to the dock of the buyer, but not for unloading. Risks, however, take a different path. The risks shift once the seller has the goods in the truck, and so the buyer has the risk of loss all the way to the buyer's place of business or destination. Now there's a third line here, and that says insurance. Insurance is a blue line. So what does that mean? That means the seller has to pay the premium on the insurance and include it in the price. But does it mean that if there is a loss, it is the seller's responsibility? Well, remember, the risk of loss shifted back at the point where the goods were loaded on the truck. So the risk shifted to the buyer here. It's just that the seller paid the premium on the insurance policy, but the buyer has to file for a claim under the insurance policy. And to the extent the loss exceeds the insurance, so long as the seller bought the proper amount of insurance, then that risk is on the buyer. This chart shows difference in two similar situations. First, under the top one, it's DAP. And you see there the costs of transportation are paid by the seller all the way to the buyer's dock, but not unloaded. The buyer must unload it. But the risk of loss is on the seller all the way to the buyer's dock. So that if there is a loss, it is the seller's responsibility. Now, in the next graphic, you'll see that the costs remain exactly the same for transportation, but the risk shifts to the buyer when the goods are loaded on the truck. And then the insurance, the third line, is paid for by the seller, but still it is the buyer's responsibility to recover and file a claim with the insurance company. So think about under which circumstance you would be better. Well, if you are the buyer, it seems like you would prefer the DAP because the costs and the risks remain with the seller until the goods reach your dock. Under the CIP, even though your cost may be the same, in other words, the seller is paying the cost of transportation and he's paying the insurance, still your risks are a little bit higher because in the event of a loss, you have to fight with the insurance company to recover the loss. Carriage paid to is also a little bit different in that the cost goes all the way to the buyer's place. The risk stops here, but at what place are we talking about? Remember, this is a C rule. And so the delivery and destination are different places. And so even though the place that you specify in the CPT rule is going to be destination, the risk of loss and the costs and delivery may shift somewhere else. Now, what kind of insurance? Well, we're all familiar with two kinds of insurance generally. One is specified peril, and one is all risk. Well, previously, Incoterms required that when insurance was to be provided, it was to be provided in a specified peril coverage. But that has been changed in this 2020 version so that generally on everything except maritime freight, the insurance that has to be provided will be all risk, but on maritime, it remains specified peril. Let's go a little bit deeper into the ocean freight. These are very similar and the graphics are the same, and I hope they help. They do me. So this is FAS, or free alongside ship. And you see in this one, the seller only has to bring the goods to the quay. They do not have to be loaded. And the risks shift when the goods are on the dock. And at that point, both the costs and the risks shift to the buyer. Free on board is slightly different in that the seller has the obligation of loading the goods onto the ship, and he has to pay those costs and assume the risk until the goods are on the ship. CFR is also a little bit different in that the seller pays the costs not only of loading the goods, but of transportation up to the dock of the buyer. Then the buyer pays for unloading and taking it from there. But risks are different in that the seller only has risk of loss until the goods are loaded on the ship. Then it shifts to the buyer. CIF, the costs of the seller, as before, include loading and transport to the buyer's dock. The risks stop when the goods are loaded onto the ship, but the seller is responsible for providing insurance, and we've said that kind of insurance is specified peril insurance, not all risk. Of course, even though I say that the insurance is specified peril or all risk, you can vary that by contract. But if you don't specify anything else, just by using CIF, it's going to mean that the seller is only responsible for buying specified peril insurance. Let me take a minute and go through a court case which covers some of these principles. This was a lawsuit regarding the sale of an MRI machine, which was manufactured in Germany and was supposed to be shipped and was shipped to Illinois. And of course, as we all love, there was only a one-page contract. And that contract stated that the MRI system will be delivered to Illinois fully functional. Somewhere on the one-page contract, it also said CIF New York Seaport. Somewhere else on that one page, it was stated the system remains the property of the seller until complete payment has been received after delivery to Illinois and inspection. So the facts were the MRI machine was loaded on a ship in good condition in Germany, but it was in bad condition when it arrived in Illinois. So the question became, where did the risk of loss shift? Well, let's analyze it. First, we have to look at what law applies to this one-page contract. Well, the contract also stated that German law controls. And so German law controls, so we have to look at what does that mean for German, what is German law? Well, German law incorporates the United Nations Convention on Contracts for the International Sale of Goods for international transactions between the United States and Germany. So you don't look to specific German law, and you certainly don't look to US law, but you must look to the United Nations Treaty. And that's what the court did. And so under that convention, the question then became, was the Incoterm properly incorporated into the contract? And let's go back up here about how to incorporate. Let's see. There. We've said earlier that the best way to incorporate it is to use the term, name a place, and say Incoterms 2020. Well, did they do that here? They said CIF New York Seaport, but didn't say Incoterms 2020. So what do you think the court held? The court said that yes, Incoterms were properly incorporated because under the United Nations Treaty, if it looks like knowledgeable parties to a contract are trying to use a term of art, then that term of art will be recognized. And here was their language. And this is the language of the United Nations Treaty. The parties are considered, unless otherwise agreed, to have impliedly made applicable to their contract or its formation a usage of which the parties knew or ought to have known, and which in international trade is widely known to and regularly observed by parties to contracts of the type in the particular trade involved. So the court held that it looks like they were trying to incorporate Incoterms, and so we're going to say Incoterms were incorporated. All right. Now, look what they did for their Incoterms. CIF New York Seaport. When would the risk of loss shift under a CIF term? Well, let's see if we can find one. Just a minute. I think I have a graphic for it. Oh, here we go. Yeah. So CIF, first of all, is an ocean-going term. The seller under a CIF has to pay the costs all the way to the buyer's dock. Risks, however, shift when it's loaded onto the boat. So, even though it says CIF New York Seaport, CIF means that the risk of loss shifts when it's loaded onto the boat, not when it arrives either in New York or in Illinois. So the next point was that the contract, the one-page contract, said the system remains the property of the seller until complete payment has been received after delivery to Illinois and inspection. So why didn't that cause the seller to have risk of loss all the way to Illinois? Well, remember at the beginning of the discussion today, I said that title has nothing to do with Incoterms. And so that provision was disregarded. So the Incoterms and risk of loss are separate from the passage of title, is the point. So where did the risk of loss transfer? It transferred upon loading the ship in Germany. The seller wins and the buyer loses. Except, did the buyer really lose because the seller had to pay the buyer's insurance, and so the buyer could recover from his insurance company? So you see how a sloppy use of the Incoterms and a lack of understanding of the Incoterms can really mess you up. Now, there's another court case I wanted to mention to you just to confuse things further. And this is a customs case where customs says that they are not bound by the Incoterm, but they look at all the facts and circumstances of the case in determining where the freight deduction should be allowed. All right, well, I hope I've thoroughly confused you and that you only have mental capacity to ask any easy questions. But if you do, I'm happy to do my best. Rudy?
Graham, thank you so much. As the folks can see now, it is significantly more nuanced and complicated than many think. I was recently talking to this gentleman about shipping something, and he said, "Well, it's just FOB." I said, "Well, that's true, but there are different kinds of FOB: FOB origin, FOB destination, and there probably are other ones that I may or may not be." Familiar with, like for instance, freight collected, freight prepaid. In any case, it is nuanced, and that's actually the point of this webinar class. Is the old "you don't know what you don't know," and if you make assumptions that are incorrect, it can cost you very, very dearly, up to having to take the case to court, and that's never inexpensive, and never the outcome is never known for sure. So in any case, it's really important to do as Graham indicated. Do acquire the Incoterms book so that at least you have a place to go and get some additional information. And if you still have questions, then you can call me or call Graham, and we might be able to help you ascertain the answer to something that's even more nuanced, and kind of go from there. But do not make any assumptions about the Incoterms. Make sure that you really understand every facet of it, not only like who's responsible from an insurance liability perspective, from what point to what point, and everything in between. Uh, and I guess at this point, let me see. I do not see. Hang
Yes,
on. Let me see.
question in the Q&A.
Uh, okay. Let me see here. Okay.
Can you see?
Rudy, while you're looking, let me mention one other thing, because you brought up about
Sure.
the FOB.
Yes, sir.
We are very familiar with the term FOB,
Right.
but in Incoterms, it is only an ocean-going freight term.
Right.
So it is not to be used unless you have a waterway transport or sea-going transport. However, there is a different set of terms besides Incoterms that are used sometimes, and those are in the Uniform Commercial Code. And those get confused with the Incoterms. So let me just remind everybody that if you intend to use an Incoterm, use that. If you use a term that's in the Uniform Commercial Code, make sure you're aware of what it means.
Absolutely. Now, Heidi, I'm actually looking at the chat, and I do not see a question. Do you see one?
There's one in the Q&A.
Oh, okay. Let me see
Yes,
here.
Kimberly Atkinson asked, using the example, since the seller still owned the MRI machine, did they get paid by the buyer?
Well, the payment is an issue that is outside the Incoterms, and I don't know. But I suspect they did because there was insurance on the transaction. And so the buyer was obligated to pay the seller. Whether he did or not, I don't know. But the buyer could recover his loss from the insurance policy that the seller had paid for. So I suspect the seller did get paid and the buyer was obligated to pay.
Yeah, and there's the other facet of it. Who is supposed to make the claim, with the insurance? That's something else that is up in the air as well, and that's specified in essence, by the Incoterms. It may very well be that I paid for it, but Graham is the one that's responsible for making the claims. I mean, it could just there's just a lot of different ways to go, and that's the point, isn't it? Is that it is nuanced. It's just, people talk about FOB and they think they understand what that is, but all of this is much more nuanced than one would think, and that's where it bites people.
Yeah. Got another comment here, further to Kimberly's question from Terrence. I would think that the transfer of title would override in the German example if the title was not to transfer unless the machine passed inspection. It sounds like the machine didn't pass inspection. So would the buyer still be on the hook?
Well, that's a good point because I didn't remember about the inspection, but you're exactly right. Now the effect of the insurance, I don't know, and I don't remember from the case how it was finally resolved. But from an Incoterms standpoint, I think the point to remember is that transfer of title is not affected by the Incoterm. But that's a good point.
It is
Maybe the buyer got out of paying because it wasn't in good
to
condition.
begin with.
Yeah.
Anything else that you see there, Miss Heidi?
Nope, I do not see anything else.
Okay, well, that's great. Well, folks, we really appreciate your taking time to attend the webinar. Our hope is that we can provide you with information that will accomplish a couple of things. First of all, make sure that you don't step on a landmine, number one, but also make you more comfortable that exporting can be done, should be done. It's in everyone's best interest that you export if you can, but to do so safely, we provide all these webinars to give you the information and guidance, and also human resources that you can tap into should you need additional assistance. And Ms. Heidi, with that, if you will go ahead and put up the information, the contact information slide, and then also in terms of our next webinar topic.
Yes. Yeah, it's trying to come up. Goodness, what is here? Almost there. There we go. All right.
Yeah, this will be a good one, Rudy. I'm really excited about this next webinar.
Yep.
There's been a strong push with the Arkansas Economic Development Commission strengthen the relationship, and we've seen some success from it for South Korea. So I think this is a highly anticipated and timely webinar at that.
It really is. And, we, of course, have increased our national security relationships with South Korea in a multitude of ways. And as a consequence of that, and on top of that, that they're a huge foreign direct investor into the United States as well. So, there is it is a good time to look at South Korea as a market to export to. They have a lot of the right pieces and parts that make them an attractive market for us. And we're going to have, I think, a fantastic webinar next month pertaining to this particular topic. So we hope that you'll register that for that particular topic. And Ms. Heidi, yes, thank you so much. Appreciate your providing that slide with both Graham's contact information, mine, Jonathan's, and Ms. Heidi. So depending, you might want to take a picture of that. If you choose to contact one of us, just feel free to do so.
Yep,
Yes.
I agree.
Yeah.
And yep, one more shout out to our sponsors of Arkansas Manufacturing Solutions and the Arkansas Workforce Connections, and their partnership in allowing us to host these fun webinars and bring in the talent like Mr. Catlett.
Yeah. A question for you, Ms. Heidi. Do we have a survey or anything this time around?
Yes, sir. We do have a survey. It will, as soon as I close the webinar, if everyone could stay on, it will pop up for you as soon as, oh, goodness, we have one more question.
Okay.
I just noticed. What main considerations should be considered under DDP terms for international sales? For example, China's shipment to the US. One last question.
You're muted right now, Mr. Graham.
DDP is certainly in the best interest of the buyer, because all risks of loss and all duties and so forth have to be paid by the seller. But there are some other considerations too, such as the buyer still has to provide the seller with the information needed to clear customs. Under DDP, the seller has to clear customs in the buyer's country, which sometimes is difficult without some assistance from the buyer. But for a risk of loss standpoint, the buyer is better to require DDP.
Yeah, it's really one of the extremes, right?
Yeah.
It's all on one end, and I think that in most cases, you want to try to negotiate a little bit closer to your end, right? Instead of you taking all the risk. In any case, do be aware of that, and with that, I think that we will close the webinar, and hope that you guys will take a minute to answer the survey instrument so that we can know how to do a better job to help you. And with that, I hope you have a great day.
Thank you.
Thanks, everyone.
Thank you.